Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am, Executive Director and Vice President for Legal Studies for the Foundation. For those of you not familiar with the Foundation, we have been in existence for 47 years this year. We are involved in trying to advance the law in a direction that's supportive of free enterprise. We do that through litigation, through amicus briefs, filing of regulatory comments, publications, blogging, and programs such as this one. Definitely appreciate everybody joining us today. A little over a year or two ago, WLF hosted a webinar on today's topic, the legal questions of whether lawsuits filed by states and localities should be proceed in federal or state court, or whether those suits could advance state law claims were still up in the air at that point. Since the time we held the webinar, however, the U.S. Supreme Court has passed on several opportunities to weigh in. Thus, U.S. energy companies now must litigate a slew of lawsuits expertly coordinated by green activists and contingency lawyers in state courts. Meanwhile, a change in leadership at the federal level has resulted in statements and actions that strongly call into question state and municipal regulation through litigation efforts and may lead to shifts in federal oversight that can impact defendants in these kinds of climate change cases. So we're pleased to have with us three speakers today. The Attorney General of South Carolina will hopefully be joining us shortly. He is the 51st Attorney General of the state of South Carolina, Alan Wilson. He's currently serving his fourth consecutive term in the office, having been elected to his initial term in 2010, in November 2013, and again in May 2021. General Wilson was elected chairman of the Republican Attorneys General Association, also known as RAGA. He served his country in the National Guard after college and was sent to serve in Iraq, where he earned the Combat Action Badge, and we are very appreciative of that. Phil Goldberg is special counsel to the Manufacturers Accountability Project of the National Association of Manufacturers that educates the public policy and legal community on why litigation against energy manufacturers over climate change is misguided. He is also office managing partner of Shakardi & Bacon's Washington, D.C. office and is co-chair of its public policy practice group. Also joining us is Matthew Leopold, who's a partner in the Washington, D.C. office of Hunton, which previously was known as Hunton Andrews Kurth, but I was told yesterday that it's now just Hunton. He previously served as general counsel for the U.S. Environmental Protection Agency, general counsel of the Florida Department of Environmental Protection, and is a former environmental litigator at the U.S. Department of Justice. Just as a reminder, we're recording this program. If you have any questions for our speakers, please add the question to the Q&A function located in the Zoom webinar toolbar. And if by chance you're watching this as a YouTube video, please like and subscribe to our channel. So I'd like to start out with these two developments this year in the U.S. Supreme Court. The first is that the justice's decision not to review a Supreme Court of Hawaii ruling that allows state law claims against Shell and other energy companies for alleged harms caused by climate change. Phil, can you give us a brief overview of that case and the outcome?
Sure. And Glenn, thank you so much for doing this and having me on these programs. You know, your programs are always so thought-provoking and really at the cutting edge of a lot of important legal issues that are going on. And so I very much appreciate you including me and obviously the other guests that we have on the panel. You know, as you said, I'm special counsel to the Manufacturers Accountability Project. And you know, we're concerned generally with these kinds of lawsuits that are trying to make manufacturers and others pay for what are really social and political issues related to how products might be used or misused. And here we have a product that is important that governments have and continue to encourage, that people rely on every day. And a lot of this litigation tries to skip over some core tenets of liability law, like proximate causation, wrongful doing. And so this is why this litigation is so important to the Manufacturers Accountability Project and to NAM more generally. The specific case you asked about, the Honolulu case, it's one of kind of two lines of cases that are going on right now. You've got the Honolulu line of cases, then you have the one that really is spearheaded by the U.S. Court of Appeals for the Second Circuit. And the Second Circuit, about I think it was in 2021, heard a similar case brought by New York City, and following the legal precedent said that these are governed by federal law, not state law, because you're dealing with interstate or international emissions. That it was, you can't hold just a handful of energy companies liable for for emissions that have gone on around the world for hundreds of years, and said this sprawling case simply beyond the limits of state liability law, and that artful pleading cannot transform the city's complaint into anything other than a suit for global greenhouse gas emissions. And that line of cases that the Second Circuit kind of spearheaded has been followed by several state trial courts, mostly in the Mid-Atlantic region. We can get into that a little bit later, but that's one set of cases that are out there. So the Honolulu case, which their ruling came out I think it was last year, maybe the year before. It tends to fly. Disagreed and took on the Second Circuit and said, no, there's no constitutional issue here. The federal Clean Air Act and the U.S. Supreme Court said displaces federal law on greenhouse gas emissions, and so state claims are viable. It said that as long as the injury occurred in Hawaii, it doesn't matter where the emissions occurred, doesn't matter whether that's all over all around the country or around the world, that these are packaged as marketing claims, not as GHG emission suits. So we can look at marketing claims under state law, and that liability doesn't regulate emissions. They still do and continue on with their trade. And that case has been followed now by several other courts. So you have a trial court in Colorado, and that case is right now before the Colorado Supreme Court, a trial court in Minnesota, and in I think this week or the week before in DC. And so the defendants petitioned the Supreme Court, the U.S. Supreme Court last year to say, hey, you should take a look at this because it's a lot of federal versus state law, a lot of interstate issues, and there's a lot of stuff here to for you to resolve because this is going on all around the country, and so it's more it's going to be more efficient for you to get in and start dealing with this now and kind of lay the ground rules. And unfortunately, the court decided not to do that. So now that's why you have all these different cases going on around the country, and then maybe the court will we'll have to pick it up at another time, but it would have been more efficient if it could have done it sooner.
Matt, can you spend a few minutes talking about what kind of federal authority the federal government has, regulatory authority the federal government has over carbon emissions?
Sure. So just to start, the primary federal agency that is currently regulating greenhouse gases is the U.S. Environmental Protection Agency. It started doing that after a finding, which I think we're going to talk about more later in the program, called the endangerment finding. That was made by the Obama administration under the Clean Air Act, and at issue there was whether or not carbon dioxide emissions from tailpipes from motor vehicles endanger or cause and contribute to an endangerment of human health and welfare. That endangerment finding was adopted, and then it set in place a number of other regulatory actions that EPA then followed up with to regulate various sectors of the economy, including the utility sector, most notably, and in a number of rules that have been litigated substantially over since that time, notably the Obama Clean Power Plan, which the Trump administration then repealed, and the Biden administration put back in place in what we call the Clean Power Plan 2.0. There's also other under Section 111 of the Clean Air Act. There's also regulation of methane from oil and gas operations. And these stem from the definition and the endangerment finding of what the administration at that time called GHG, which are 6 well-mixed global pollutants as included in the definition. And so that's been the pollutant as defined under the Act that has been the basis for GHG regulation. There also have been some other enactments over time, particularly Congress specifically spoke to the regulation of HFCs in a 2019 law known as the AIM Act, and that in a new statutory enactment started to phase down the global emissions of HFCs and the import and manufacture of HFCs, which was one of the pollutants identified in the endangerment finding. And EPA has also been regulating or states through their permitting process emissions from Clean Air Act sources that were otherwise permitted in the Clean Air Act Title V program. There are other regulatory processes, including a reporting rule under the Clean Air Act that tracks emissions across the United States from various sources. But at this point in time, as I'm pointing out, there are a number of significant, ongoing, and important GHG regulations for various sectors of the economy. Not to mention where it all started is with respect to tailpipe emissions from motor vehicles and heavy-duty vehicles and other categories as well.
Thanks, Matt. So now that the Supreme Court's decided not to decide, at least on the state law issue, where do things stand with these suits, Phil? How many states and municipalities are pursuing state law claims in state court?
Yeah, so right now there's about 36 of these lawsuits around the country, some by local governments like towns, some by counties, some by states. And it's starting to look a little bit like legal spaghetti being thrown at the wall to see what sticks. They're being brought under a variety of legal theories. Public nuisance was the first theory out of the box. That hasn't proved to be very successful. Now they're trying Consumer Protection Act claims. A lot of states are saying that that's not very successful because a lot of the things are saying that the companies did wrong happened 20, 30 years ago. And obviously there's statute of limitations with a lot of that. And the things that they're saying that are ongoing are not things that the court says are actionable. You have a RICO case in Puerto Rico. You've got a few other things, types of cases that are going on around the country. And there's also one of the interesting things is the other side talks about the sort of grand conspiracy about what people in the industry said. But the litigation also mixes and matches various types of defendants. And so some go after one company, some go after two, some go after 6 or 7, and some honestly like 36, including local gas stations or to try to keep the cases in state court. And so that kind of undermines the idea that there's some cabal of thought that was intentionally doing something here when you constantly are changing who supposedly was in that room. And back in 2011 when AEP versus Connecticut was being heard by the Supreme Court, the Obama administration filed a brief, the Solicitor General did, and explained this problem with the litigation in that in that brief, saying that deciding who to sue is capacious was the word they used, and that it's just you're dealing, anybody could be a plaintiff and anybody could be a defendant in these kind of climate cases, and so it's really become a political decision about who files suits, who they name, and all of that. And in fact, you have the people who are behind a lot of this saying in the media that we look at the politics when we decide where we're going to go and try to recruit plaintiffs. And so there's, as I said, there's about 36 of them around the country right now, and they're constantly trying to figure out how to line up more people, because in a large part for them, just filing lawsuits is part of their agenda, and because they want to leverage the media and all of that goes around the litigation in order to advance their political goals here, which is to regulate the oil and gas industry through the courts. Glenn, we can't hear you. I know we're waiting on the Attorney General. So it sounds like you're heavily in negotiations over there to try to get him.
Yeah, I am heavily in negotiations trying to get General Wilson on everyone, and I'm sorry, we will get that done. Can you spend a little bit of time on the decision that was made by the court in Maryland involving the Baltimore case? That's one of the ones that I think did a very thorough job of analyzing a lot of the issues involved in these cases.
Yeah, sure. So as I said, the Second Circuit kind of spearheaded this line of cases that have said these are not justiciable cases. These are not liability issues for courts. These are really policy issues for for federal agencies, and these aren't state issues. These are federal. All of that. And so you had trial courts in Delaware in response to the Baltimore and then Anne Arundel and Annapolis cases, New Jersey, hearing New York City's second or actually third attempt at this litigation, all following the Second Circuit saying that when AEP versus Connecticut in the Supreme Court ruled in that, it held that the federal claims there were displaced, but it also went on to say a lot more than that. It explained that this was an issue of special federal interest and that the application of state law is inappropriate, that federal agencies, are the way to handle these issues, not rulings, by judges on an ad hoc basis, and that courts just don't have the institutional tools to weigh a lot of these issues. And whether it's, affordability, when you're talking about national energy policy, you want to focus on affordability, on energy security, on climate, other environmental issues. And you kind of have to figure out what works best. And courts just can't do that when you're dealing with these lawsuits. And that's a lot of what the Baltimore court said in its ruling, and explained, it kind of went through a lot of the key issues that, that the courts are looking at, kind of legal issues. And one of the things was, is this case regulation, right? So the Hawaii courts say, no, this is not regulation. We're just, it's just asking for damages. And the Baltimore case said, no, asking for damages is a form of regulation. And so, the idea of liability is to be able to stop the unlawful conduct that's causing the liability. You don't assign liability for something that's not unlawful. And so that's why liability regulates. It talked about, global and, emissions and interstate emissions, and said that only federal law can govern, these, a lot of times it's, we're dealing with foreign emissions, there's foreign policy issues, and that's forecloses the ability of any state to bring in a remedy. And that obviously federal law governs interstate emissions. And then it kind of went through the various legal theories here, from public nuisance to Consumer Protection Act and others, and said, that's just reframing or recharacterizing the litigation, but these are not differences that have a legal distinction. And largely said, its phrase was, you can't get in the back door what they can't get in the front door. And it kind of went through and explained why that was the case. And so those courts have said, and that case has been appealed to the Maryland Court of Appeals. That case is currently, and then it's been merged with the Anne Arundel and Annapolis cases. And right now it's in a little bit of a hold, because it's unclear whether the Court of Appeals is going to rule on it, or if that's going to end up they kind of get an express ticket to the Maryland Supreme Court. But that's kind of where that case is. The Delaware case, which I don't know if I should filibuster waiting for the
yes, please let us talk about the
Carolina
Delaware
Attorney General to join us. But the Delaware case was very interesting, because the Delaware trial court said, you can't sue for emissions or things that happened outside of Delaware, right? Like we in Delaware only can govern what happens here. And so if you're suing for emissions in, Missouri, Kansas, California, or, other countries around the world, we don't govern that. And so you have to bring this lawsuit for only looking at what emissions or what took place in Delaware. And the plaintiffs then appealed that to the Delaware Supreme Court, saying that trying to get that overturned and acknowledging, no, we want to sue in Delaware for damage that occurred in Delaware, where things took place all around the world, where things took place over the last 150, 200 years. We understand that the activities at issue here are all over the globe. And the Delaware Supreme Court didn't take their request to hear it. And now you're in a very interesting situation where the plaintiffs are saying, or the state of Delaware and the private lawyers that they have retained to bring the case are saying, we don't want to litigate this case. We don't want to litigate a case that just deals with what happened in Delaware. And they're trying to get the case dismissed and, and get a final judgment so they can appeal that. I shouldn't say dismissed. They're trying to get the case to a final judgment saying that no, and then they can appeal that final judgment to the Delaware Supreme Court. They don't want to litigate a case like that. And it's interesting that they fully, kind of showed their hand and said, yeah, we do want to sue for what's going on around the world, not just, we don't want to sue in Delaware for what's happening in Delaware, or in Hawaii for just what's happening in Hawaii, or New York for just what's happening. We want to be able to sue for things all around the world in all these different places. And that goes back to what the Obama administration said back in 2011 was just, this isn't the kind of focused liability issue that we see under state tort law. And that's one of the reasons why this isn't appropriate for state law.
Senator Wilson, thank you for joining us by phone. Sorry for all the problems getting you on.
No, not a problem.
So we're going to back up a little bit here. We've talked about the Sunoco case that the Supreme Court denied cert in. That was one of the Supreme Court developments. The second one was about a year ago. 19 states, including South Carolina, filed an original action in the Supreme Court against 5 states that had attempted to regulate interstate carbon emissions through civil litigation. General Wilson, can you tell us about that action and your thoughts on why the court decided not to hear that case last month?
Well, first off, the complaint that the states brought, or at least the issues that we raised in the brief, were basically the concept of horizontal separation of powers, exclusive federal authority over interstate emissions, and the Commerce Clause. But generally speaking, I'm going to take a step back. This is an issue that we've been dealing with for years. When states and local municipalities are bringing local tort laws like public nuisance, is one of their favorite go-tos, public and private nuisance, strict liability, things like that, and they're using it to dictate federal or national environmental policies that cross state boundaries. This has been a problem for us. As you're already aware, we had a similar situation with one of our municipalities in the state of South Carolina trying to do the same thing. That's the city of Charleston. When I go back and I look at our briefs, one of the things that was said in a prior Supreme Court case that kind of sums up for me our reason for getting involved was something that was said in Coyle v. Smith, which is a U.S. Supreme Court case from 1911, where the court basically said our federal union is a union of states equal in power, dignity, and authority. And that's kind of that also sums up kind of my views on federalism. Federalism is both the vertical relationship between the federal government and the states, as well as the horizontal relationships with the states amongst themselves. And you're always having to balance the power, or I guess the interest of those competing sovereigns. The federal government is a sovereign, each individual state is its own sovereign, and you have those relationships that go between them. So when you have states, in this case, like California's done it, Hawaii's done it, New Jersey, Vermont, New York, among others, when they're passing or when they're bringing cases in state courts and trying to dictate national environmental policy or national policy of any kind using state tort law, it violates that tenet of all states having equal power, dignity, and authority between each other. So again, I'm a states' rights guy. I'm a big believer that the states, should have as much autonomy. They have general police powers. They should be able to do those things. But at the same time, from a policy perspective, I always ask this question: any time that a state or a federal government does something, it has to pass a 5-way test for Alan Wilson. Is the thing that is being done, is it responsible? Is it predictable? Is it accountable? Is it profitable? Is it stable? The first 3 are really the tenets of good government or good governance, and the last 2, profitability and stability, are byproducts of it. Let me explain what I mean by that. If you have individual states creating super funds and bringing tort actions to dictate national policy in different states and even different municipalities, is that responsible from a national standpoint? Does that create more or less predictability in the markets? Does it create more or less predictability in our court system if you have a hodgepodge or a patchwork of different jurisdictions competing with each other on how they're adjudicating various local state claims. I think the lack of predictability creates cost to the end user. That's the consumer. So if you have, and whether it's a car manufacturing having to deal with emission standards in California compared to the rest of the country, or it's energy companies like oil companies having to, account for the lack of predictability in, with the various states taking various policy positions in state courts, and you have to account for that lack of predictability across the 56 states and their territories, then that is going to increase the cost of energy production. It's going to increase the cost of litigating itself is going to get passed to the end user, and those are the consumers of our respective states, namely the people in South Carolina. I don't know, it might maybe an oversimplification, but that's why I take these types of cases very seriously, and that's why the state has signed on to the cases we have.
So you elucidated a lot of those, if not all of those principles really well in just 8 pages in an amicus brief that you filed in a case that Charleston, South Carolina, filed against a number of energy interests. Can you talk a little bit about that brief and why it is that you decided to participate in that case?
No, absolutely. And, for the reasons I already said, that was a case in which the city of Charleston sued a bunch of major oil companies asserting state law claims like public and private nuisance, strict liability, negligent failure to warn, trespass, and South Carolina Unlawful Trade Practices Act claims were also in there. They brought all these in state court. And so we filed an amicus brief raising many of the same points, that I just talked about. But basically, the lawsuit raises serious constitutional concerns over the equality of the states and the need for a uniform federal rule to resolve the issues. Again, I'm always going to defer to states and their general police powers and their abilities to govern themselves. But the water and air at a border of a state doesn't stop there. South Carolina air doesn't stop being South Carolina air at the North Carolina border. You've got to have uniformity. Uniformity creates predictability. Predictability is more affordable than a lack of predictability in the free market, and a lack of predictability in the court system. When courts are when plaintiffs are injecting themselves in the court system to try to create policy by judicial fiat in a random haphazard way throughout the country in multiple jurisdictions, you're creating havoc in the free market. And so again, even in our own state of South Carolina, we have one of our own cities doing this very thing. And in the opioid litigation, you have a lot of municipalities. There were thousands of plaintiffs in the opioid lawsuits. And you had, in South Carolina, we had dozens of local municipalities trying to jump in. And my position was, I can't stop a municipality from getting involved, but I try to remind these folks that the state is the state, meaning that the state of South Carolina represents the state interest as well as all of its subordinate interests. Municipals are subparts of state government or subparts of the state of South Carolina. So when we bring a lawsuit, we're representing the interest of everyone in South Carolina, even at the municipal level. And so when those municipalities weigh in, like the city of Charleston does, they're creating problems for me as a person who represents the entire interest of the state of South Carolina. And so again, back to my original point on the Charleston case, I don't think it's right for a city in California or a city in Hawaii, like Honolulu or any other state, to try to dictate national environmental air quality or water quality standards through tort litigation in a state court in those states. Why would I condone it in South Carolina? I believe uniformity is our friend. I believe predictability is our friend. And I believe as a matter of policy, the states created the federal government to do things it couldn't do things either it didn't want to do for itself or it was unable to do for itself. States are not in a position to determine air and water quality standards, and we shouldn't rely on state courts to do that. That is what we created the federal government for. And so that is kind of the point we make in our brief here in the city of Charleston case.
Thank you, General. Phil, the General mentioned one of the claims that's being brought in these cases, the public nuisance claim. Have there been any substantive decisions issued in any of these decisions so far on whether or not these municipalities or the states have the ability to pursue public nuisance claims in this context?
Yeah, so I mean, it's if you go back to AEP versus Connecticut, which was the 2011 case that was brought under federal public nuisance law, and the U.S. Supreme Court said no, that's been displaced under the Clean Air Act. So then the question becomes, are state public nuisance laws suitable to do this? And as I mentioned, the U.S. Supreme Court, the U.S. Court of Appeals for the Second Circuit said no, but more under the fact that if federal isn't, then also state isn't. And that's, I think, what we've heard from a lot of the courts. None of the courts have really gotten into the doctrinal issues of what a public nuisance is and how it applies here. And one of the things that I think is problematic, well, two things I think are problematic for these public nuisance cases is the idea of a public nuisance is to protect, the government protecting the public's right to use like public roads, public waters, that kind of thing. And so the purpose of the lawsuit is to unblock the road or to clean up the water so that the public nuisance doesn't exist. None of these cases are about that. They all say, a lot of them say that, we're not looking, we're not trying to regulate emissions. We're not trying to do anything about climate change. We just want money because, we're going to have to do climate adaptation locally. And by the way, that's going to happen around, the country and the world. And so, that's not what public nuisance is about. It's not about giving governments money to deal with something that they have as a local responsibility. The purpose of public nuisance is for the government to vindicate the right of its people to use the public roads and waters and free that up. And so a lot of times money damages is not available to governments at all. It's just injunctive relief and abate the nuisance. And once that's happened, injunctive relief stop causing a nuisance and abate, the nuisance, so the nuisance no longer exists. And that's what the Oklahoma Supreme Court said a couple of years ago in the opioid case. And you could pay the state money to deal with opioid and prescription drug issues, but that doesn't mean that the nuisance goes away. And so that's why, these cases aren't really viable from a public nuisance, among many reasons why these cases aren't viable from a public nuisance. The other is, causation issues alone would be problematic under any tort theory, but certainly for public nuisance as well.
Yeah, I'm glad that you mentioned the sort of artful pleading that goes on in a lot of these cases, and that's what the Second Circuit and the Baltimore, the court in the Baltimore case noted was you can call these consumer protection claims or greenwashing or whatever you want to call them, but you're still looking to use regulatory authority over carbon emissions, which you can't do that at the state level. General Wilson, have you been encouraged by decisions like the one that have occurred in Baltimore, the Delaware case, the New Jersey cases?
No, absolutely. It is encouraging. Obviously, I don't know if my encouragement in those cases is outweighed by my discouragement in the Honolulu case and the Alabama case. But I am, and I think in your previous question, I don't know if I addressed it, and I'd be interested to hear what the other panelists say, why the Supreme Court is not taking these up. And again, while I am happy with some of our successes, until this is resolved at SCOTUS, I think this is going to be an ongoing issue. And as the last panelist just said, municipalities and some states are trying to are trying to get revenue to address or remediate these issues that they see as coming from climate change. There's a better way to do that. That is through appropriations of the people's elected representatives, either at the state or federal level. That is a more predictable way to get those funding. That way people can come in and debate and advocate for funds to address the concerns brought on by global warming or whatever and I'm doing air quotes right now, the public nuisance is. But doing it through the court system, I think is very problematic. And why the Supreme Court hasn't taken that up, I don't know. I'd be interested to hear why some of the other panelists or what their positions may be. But I would surmise that it would probably be that maybe they prefer to have a record built in the federal court system as opposed to direct, petitioning the original jurisdiction or possibly jumping from a state Supreme Court record in federal and state court. Maybe they want this to go through the regular process of going through federal district court to court of appeals. I don't know if others have an opinion on that, but obviously until it's taken up by SCOTUS, this is going to be an ongoing issue for the states.
Bill, any thoughts on the Supreme Court's sort of lack of interest right now?
I mean, I share the Attorney General's frustration, as I think I indicated before, that it would be, with all these cases all over the country, it would have been very helpful for the Supreme Court to at least lay down the standards and the rules of the road for how these cases should be looked at. I think the general is right that the Supreme Court didn't want to take a case that didn't go through the whole regular process, and that there are certain canons that they tend to follow, and that's one of them. That this wasn't kind of ready yet. They don't explain, what their thinking is, but if you're reading tea leaves, trying to understand why they might not have taken a case of this magnitude and these kind of legal issues, that tends to be what most people I've spoken to have focused on, and that everybody expects that this is going to get back up to the Supreme Court at some point. And in fact, the Solicitor General in the Biden administration said these are important issues for the Supreme Court to address, just not yet. And I thought was very interesting is that she even walked through what those concerns are, what the constitutional concerns are in her brief. She said that that these may be preempted by constitutional federalism issues that the general was talking about. These may be preempted by federal law and the Clean Air Act. But it's just not ready for you to tell us that yet, because that was what I thought was very interesting. But I do expect this is going to end up back before the Supreme Court at some point.
I know, General Wilson, you have a scheduling issue that's going to make you have to jump off in a little bit. So I want to ask you, make sure I get one more question in for you. You had mentioned the issue of municipalities participating in opioid litigation and now in these sort of lawsuits. Are there any sort of mechanisms that states have to be able to maybe not stop or prevent, but frustrate municipalities from doing this? They seem to be very interested in what the plaintiffs' lawyers that go and visit with them have to sell.
So, yeah, I mean, states have the authority through their state legislatures and their governors to pass laws that limit the authority of municipalities to do this. The problem is the state legislatures are made up of who? Elected representatives, many of them are who? Plaintiffs' lawyers. And I'm not knocking, I have a lot of good friends who are plaintiffs' attorneys who perform valuable functions, but the solution is buried in a problem. Is that the way to curb municipalities from getting involved is to go to the very people who possibly could be perceived as benefiting from that involvement. And so it is an issue. The Attorney General in South Carolina is the state's chief legal officer, and I do have the authority to control state litigation, but I don't have the statutory authority to stop a municipality from getting involved. What I do talk, like during the opioid, I had lots of conversations with lots of mayors, lots of city council members from various jurisdictions who were jumping into the opioid litigation, and they were being recruited by plaintiffs' firms who wanted a vehicle to get into the opioid litigation. And I was telling them, listen, any money that you get from your engagement with this individual firm is going to be, any money that I bring to you as the state's attorney general could be offset by, monies paid in attorney's fees. And so, but by the time that I'd had that conversation with them, they were already party litigants. So, but again, it's a policy question. Do the states want to limit municipalities' ability to get involved in these types of cases? That is a question for the state legislature and the governor to situate. I would certainly advocate for something along those lines, but those are just my initial thoughts.
Thank you, General. So we have these lawsuits, and now there are several states, including Vermont and New York, that have passed these so-called climate superfund laws. Matt, President Trump recently issued an executive order on state legal and legislative actions against energy producers. Is that a reflection of an increased amount of federal level frustration at what's going on and the fact that the federal courts have not been able to step in on this?
Yeah, well, first of all, you mentioned the climate superfund laws. So let me just speak to that for 1 minute, because I think those are directly related to the executive order we saw from the president. And for those who don't know, I mean, Vermont, New York enacted these laws to allegedly mimic the federal Superfund law for pollution cleanup, and it creates retroactive liability for prior emissions of greenhouse gases for companies that have previously extracted or refined fossil fuels. And they establish strict liability for out-of-state sources of GHG emissions, and they attempt to allow for cost recovery claims for entities that were engaged in the business or trade of extracting fossil fuels or refining crude. And those are, as a result of the emissions that occurred from those, the extraction and refining for global emissions. And there are particular periods that each law has associated with it. And these are very extraordinary. And they're a new species, if you will, of state law that takes, some of the concepts that are already being used and litigated of what we've been hearing about, and then applying it more in a regulatory framework, right? And the states frame it as cost recovery, but they expressly mimic, to some degree, environmental regulation that EPA has under other programs. And so this is a new and daunting challenge to the Federalist framework set under the Constitution. And there's already litigation that has been filed by the U.S. Chamber of Commerce and the American Petroleum Institute against these laws, both Vermont and New York. And we can talk about that a little bit more. But against that backdrop, the president issued an executive order on April 8th called "Protecting American Energy from State Overreach." And if you've been following, energy dominance is one of the main themes of this administration with respect to environmental regulation. And the order expressly states that states around the country who attempt to target or discriminate against out-of-state energy producers are creating barriers and causing constitutional questions and concerns. And that it runs counter to the federalism framework that under the Constitution, and there as well, these laws are potentially preempted by federal law. And so the order directs the Attorney General of the United States to consult among the federal agencies and identify state and local laws that would hinder or burden the development, siting, production, and use of domestic energy. And the AG is then supposed to identify within 60 days in a report back to the president a plan of action to stop the enforcement of these state laws. And so this is, I think, quite extraordinary. I think it portends pretty significant action potentially coming out of the Justice Department. And what we might see is, along the lines of the litigation that's already been filed, but having the United States getting into this space and asserting federal rights and preemption, I think it is something that a lot of folks have commented could be very useful.
The EPA has signaled that it's going to be reviewing and potentially withdrawing the carbon emissions endangerment finding. Matt, what kind of process does EPA have to follow for that? And what impact might it have on these state and municipal lawsuits we've been discussing?
Right. So the endangerment finding, as I was mentioning earlier, is really the cornerstone of all EPA regulation of GHGs under the Clean Air Act. And it one of the very first executive orders the president issued, he ordered EPA to review and come back with a plan to potentially revisit endangerment. We still don't know a lot about what approaches might be taken, but we have now reports that the EPA has come back and affirmatively said it's going to review and revisit. In some of the materials that have been released by Administrator Lee Zeldin, it talks about that there wasn't an opportunity for notice and comment previously when in 2009, and that is necessary given the changed legal landscape, particularly on administrative law. We've had landmark cases like Loper Bright, which eliminates the former Chevron deference doctrine, which underlied and for many years a lot of EPA policy decisions. We also have the major questions doctrine under West Virginia EPA that came down in a challenge to a greenhouse gas regulation for the power plant sector that the Supreme Court invalidated. So the legal landscape for administrative law has changed dramatically. There's also indications in some of the materials that EPA has released is that they are that they have noted that EPA invented this term GHG in 2009 as part of the finding and didn't solely focus on dioxide emissions from motor vehicles, which was the regulatory basis for the initial petition that was granted. So that might indicate there's some thinking going on about, how to separate that out or revisit that grouping of those greenhouse gases together. But what we do know as far as process is concerned is they're going to go through notice and comment. And so we expect something on this soon, and indications are, EPA is working on it actively. And so, all the theories will be laid out in a notice and comment process. And then I think the question after that is that challenged and how does that impact all the regulations that rely in some way, shape, or form on the endangerment finding?
There's a provision, Matt, of the investment of the Inflation Reduction Act that references carbon emissions. How does that fit into the discussion of federal authority here over GHGs?
Yeah, I mean, one, and you're referring to an enactment that Congress made to create a grant program for climate grants that EPA could issue, pretty significant in terms of the scope and the scale of the funding that's been provided by EPA, which has historically not been a huge grant-making agency like other agencies. But buried in that grant program, Congress did include a definition of GHG, which aligned with the definitions that were initially codified in the endangerment finding. So it included, CO2, methane, nitrous oxide, HFCs, PFCs, and sulfur hexafluoride. So that was tied to those grant programs. The other thing Congress did that's maybe of relevance is it created what was called the waste emissions charge for methane for states, and that did not for situations where the methane was not regulated under EPA and state regulation. Interestingly, now Congress has passed a congressional resolution of disapproval of a rule that the Biden administration promulgated for the waste emissions charge, but the statutory provision is still in existence. So those are the two elements that Congress injected new legislation.
Thank you, Matt. Phil, I know you need to catch a plane flight, so let me just ask one more question. sort of from a broad perspective, what's the sort of doctrinal concerns that if any of these state or municipal plaintiffs find success in their claims, like what kind of Pandora's box do you see that opening up potentially?
Yeah, I mean, the basic thing is that it's going to increase the price of energy for everybody. Because if all of a sudden we're relying on the energy companies to provide funding for all, for climate adaptation all around the country, then it's going to cost a lot more to, fuel your car or turn on your lights at home, heat, cool houses, run plants, factories. And that is going to be borne by Americans, not other people, because these lawsuits are only targeting the people who are giving us energy, not the ones all around the world and in other countries. So it would become a big disadvantage to American industry, and it would become a big expense for a lot of families that can't afford it, which is one of the reasons why these are not really liability issues for courts, but things that Congress and policymakers need to decide as to how to balance all of these things. The other thing I want to point out, as we heard both General and Matt talk about, is the idea that you need this litigation, or this litigation is an efficient way or even a good way to fund local climate needs is just a fallacy. There were, as Matt said, significant grants. I think the National Taxpayers Foundation put out a report a year or two ago saying it was like $41 billion worth of funding for these kinds of projects. That money goes directly to solve the problems that these communities are saying that they have. If these lawsuits end up going anywhere, they got to pay like a 20 to 25% vig out to the plaintiffs' lawyers who are bringing these cases. And all of a sudden, that money, which is costing Americans, higher energy bills, are going to, at least a quarter of it is going to pay the trial bar, not going to actually solve any problems. And so the more efficient way for communities to get, to have the resources they need is to do it through state, federal grants that are designed for this purpose. And so that's, rather than, dealing with this kind of litigation that is, again, it's more political. We understand that. But even to your point, if it were ever to be successful, it really could be ruinous for a lot of people.
Thank you, Phil. Sort of to the same point, Matt, with the state climate Superfund laws, I imagine you'd see quite a few of the same sort of impacts, not involving the plaintiff's lawyers' fees, however, but the cost of energy, et cetera, if those laws go into effect, survive these challenges.
Sure. Yeah, it could have significant impact in terms of these quote unquote compensatory payments by responsible parties that these laws allege. And remember, this is strict liability. And so, and Vermont's still assessing, which parties are potentially responsible and in what degrees and amounts. But it just reinforces in my mind the logic and really the better argument that we have a national regulatory approach to GHGs under the Clean Air Act currently, and the Chamber and API lawsuits make this point significantly that the Clean Air Act preempts these sorts of laws, particularly when they're aimed at emissions and emissions that were lawful in other states and oftentimes emitted subject to a permit that was lawfully issued. And so there are a lot of arguments here that preemption and should be found, and we'll see what happens. These cases are in federal district court at the moment, so that's a plus. But I think going back and the retroactive nature and aspect of these laws is particularly challenging and could raise the price of fuels, raise the price of goods, have all kinds of effects that are better balanced under a national federal regulatory approach.
Glenn, one of the things that I think, and Matt just kind of touched on it a little bit, is how we consume energy, how we produce energy, and how we've done it for the past 150 years is going to change, and it is changing. To be more climate friendly, to reduce, be more efficient, reduce emissions, and all of that. The key and reason why kind of the liability aspect of this doesn't work is because it's retroactively saying, hey, you did all this, we needed this, you gave it to us, and now we're going retroactively to say that was bad, you should have to pay for that, as opposed to if you want to change and regulate ways to facilitate new energy sources and better use of current energy sources, that's a forward-looking question. And that's something that regulators can do, that Congress can do, that states, can certainly do within their own, within the bounds of federal law, within their own areas. But that's what we need to be doing. We need to be coming together as a country and as a world, frankly, and say, okay, how do we get to where we want to get to from an innovation perspective, from a policy perspective? How are we going to reduce our energy footprint on this planet? And then let's work backwards and figure out how to get there. This litigation does none of that, and it only distracts from the very important work that needs to be done.
I want to add a fact, thanks to one of our attendees. They sent in through the chat that a bypass petition in the Maryland Supreme Court was granted this morning in the Baltimore case. So that's been docketed for the September 2025 term. So I really didn't think that we're going to be breaking news in this program. But
I knew that was in the offing, but I wasn't sure that it was granted. I didn't know it was granted this morning.
Right. So. No, we definitely appreciate the attendee who sent that in. Well, seeing as we don't have any questions from our viewers, we're going to bring this to a close here. I want to thank Phil and Matt and General Wilson for participating. Once again, sorry that General Wilson's participation was a little bit limited, but we're certainly glad we were able to get him on in the end. This, as I said at the beginning, this is going to be being recorded, and it's going to be available as an on-demand file later on. So if you came in late or you know somebody who might want to watch it, we'll be sending out an email to everyone who registered to have access to that. Once again, gentlemen, thank you very much for joining us today.
Thank you.